I think everyone in the call maybe understands the contextual part of the work that we're doing today, but I think let me just quickly give a brief intro. So we were approached by the Beautiful Gate South Africa and Philippine Economic Development Initiative. These are two NGOs that are working in Philippi, supporting the two informal settlements of Sescona and Winnie Mandela, in helping them think through a collective land holding instrument that would work for them should the landowners be willing to sell the land to the community, which is likely to happen. But we need to think through what instrument we can use. So we began our conversation on this platform talking about community land trusts, but it is becoming uh, increasingly clear that we need to explore other instruments, not only focus on the community land trust, other instruments that would work in our South African context as well. We do not have a legal status, so to say, for community land trust in our South African context. So we've learned of experiences from the global South countries, and today we will be having two people that will be leading conversations on our South African context. And that is Dr. Tara Wenbeck from Wits University and Dr. Tanvir Jiwa from the University of Stellenbosch. So we are already 10 minutes into the call. I know we're quite strict about time. So after the conversation from both speakers, we'll then take a deep dive into the working groups, Greg, as far as the plan is concerned. Yeah. So without wasting time, can I ask you, Tara, if you can start? Tara will be speaking to the historical land holding instruments and legal entities that were used in South Africa in the apartheid era, and also just in terms of today's conversations. She will also contribute to that. Thanks.
Thanks, Akona. So, what I'm going to be speaking to, as Akona said, is quite historical. I looked at collective forms of land ownership that Black farmers, mostly in rural parts of South Africa, developed in the early 20th century, the late 19th and early 20th century, and how they continued to try and persist with these models of land ownership in the context of the colonial and apartheid systems, where the law was stacked against Black South Africans being able to own land in the form of title deeds. So, one of the ways to get around these restrictions on Black South Africans owning title deeds was for groups of Black farmers and families of sometimes a few hundred families, so 250 families, for example, would come together and establish what was called during the time a land buying syndicate. So, in other words, a kind of land buying company. Some of these companies were registered under the Companies Act of 1909 in South Africa, and others operated more in the form of trusts, community trusts, rather than companies registered under the Companies Act. So I guess just the caveat here is that a lot of what I'm talking about relates to my research on rural areas rather than urban areas, but hopefully there are some learnings that we can also pull from that history in thinking about urban areas. So this research originated when I was working at the University of Cape Town, and we were doing a lot of work with land restitution claimants in South Africa who were about to receive transfer of land through the land restitution process, so land that they had been dispossessed of uh, under colonialism and apartheid. And often these land restitution communities wanted to receive land not only as individuals, but also as groups or as communities. And so they were trying to figure out the best entity they should use to hold land. So I guess similar to this question that you mentioned, Akona, in relation to people thinking of owning land in places like Philippi and how to own land as collectives and not necessarily in the form of individual title deeds of like one title deed per person or per family. So this was the challenge that people were trying to figure their way out of. And there were two entities in rural areas that were most common that people were using in these kinds of land claims. The one was community trusts, which I know you also mentioned, Akona, as one of the options that people had been looking at in Philippi. The other is communal property associations. These are entities that were developed through an act of parliament in South Africa in 1996, the Communal Property Associations Act. And it basically set up legal entities through which people could manage land as groups. It stated a number of things that need to be in place in order for people to take transfer of land and manage land. So this included, for example, the election of a committee annually to govern the affairs of the community that they represent. It also included a constitution which would outline the regulations and policies of that particular community. And the constitutions would differ depending on the historical land tenure practices of that community. So it was meant to be something that would be developed from the ground up based on the rules and regulations of people, the way the people lived, either according to the rules and regulations that they practiced in a social sense, so in a de facto sense, or in a customary law sense. But we noticed that in doing this land restitution work, that there were a lot of problems with both trusts and communal property associations that people were running into. These included things like the committee of these institutions abusing their power, so making deals, for instance, with mining companies or other business partners without properly consulting the community as they were supposed to do according to their own constitution or according to the rules of the Communal Property Associations Act. There were also issues where elected committees were remaining in power for more than a year. There were issues where there wasn't adequate gender representation across the committee. And there were tensions also between different rights holders within the outer boundary of this kind of collective landholding entity, because one of the things that would take place is that when land was transferred to this community, it would be transferred into the name of the Communal Property Association or the name of the trust. So the kind of outer boundary of this title deed registered in the deeds registry would be in the name of the Communal Property Association or trust on behalf of the individual members of which there were lists of that trust or communal property association. And so this work occasioned me into looking into a longer history of collective forms of land ownership in South Africa. And I'm just going to give you one case study today from my PhD research. The reason for this was partly because when we asked people, why are there problems with these entities? And a lot of government officials would often, and traditional leaders or chiefs would often say, oh, these are brand new entities. They're like features of the 1994, post-94 dispensation, and they're imposed on people. They're not customary entities, or they're not entities that match people's realities. But in speaking to people, it became clear that this wasn't the first time that people had to establish collective forms of land ownership, that they had done so in the past. Collective resource management kind of entities had already been in existence in the past. So people spoke about land buying syndicates of the early 20th century. They spoke about cooperatives. They spoke about women's church groups, sometimes called manyanos in South Africa. They spoke of savings clubs and civic associations and so on. And so it's clear that there's a long history of collective practice in South Africa around the management of resources. So the question then was, what's going wrong with these in the context of land reform with these collective landholding entities. And I'm not sure that my historical research provides a direct answer to that, but I think it provides some hints of what maybe worked and what didn't work in the past. So the entity that the case study that I want to tell you about is a syndicate that was established in 1912 in what is today the Mpumalanga province of South Africa. What was then it was called the Transvaal province. It was established in a number of areas. The most famous towns in that area are now called Dachakral and Driefontein. They're located near the town of Piet Retief. And it is a sheep farming and maize farming area. There were about 250 Black farming families that came from all over the country to buy land as part of a collective land buying scheme. And they were brought together by Pixley Kaseme, who some of you may have heard of. He was a South African lawyer and one of the founders of the African National Congress in 1912. And it was Seme and other Black lawyers at the time had this idea that one way of getting around the racist legislation of the time was to buy up land in large quantities and to create companies or syndicates that would then manage this land and allow Black farmers to live on kind of subdivided land within the collective purchase agreement. So people would act as shareholders of the company as well, each family that bought into it. And this is what happened in Dachakral and Driefontein in 1912. So there was a board of directors. It was all, the board was run entirely by Black directors, so Black politicians, lawyers, intellectuals, farmers, and so on. There were committees that were established within the syndicate who would manage things like allocating land and adjudicating disputes around who should have access to water sites, to common water sites, and so on. And so it was a situation of a very regulated commons within the syndicate's land. The syndicate was called the Native Farmers Association, and they were successful in getting around the laws of the time. So the government actually tried to have them disbanded on the basis that this was soon after the 1913 Land Act, which said that Black South Africans could not own title deeds. So the government argued that Seme, as the director of the company, was a Black person, and therefore the company could not have bought land from a white landowner in this way. And Seme successfully argued up until the Supreme Court of Appeal in South Africa that companies were not racialized in South African law. And so this was a way for him to get around the restraints of the 1913 Land Act. And the background, the kind of archival evidence is very interesting on this, because you see colonial administrators of the South African Union government at the time basically saying, he's got us. We thought we could crush the syndicate, but he's correct in law, and we have to agree that the company can continue to exist. The South African government was very threatened by syndicates like these, because they said, well, imagine all over the country, Black farmers come together, and while they may not be able to buy land as individuals, they form these collective entities and buy land as companies. And they could be quite successful farmers and outcompete white farmers who were not yet at the level of like white commercial farmers, the kind of monopoly that white commercial farmers have over agriculture in South Africa today. So it was like a moment of possibility for Seme and other Black farmers at the time. So as I said, the way that things ran within the syndicate is quite interesting. It developed its own constitution and set of regulations around the election of board members, around the election of committees representing segments of the land within Dachakral, Driefontein, the overall piece of land that the association had bought. And so in general, it seemed to work quite well for a number of decades. There were also problems within it. So, for example, there was abuse of power by certain leaders and members of the board of directors. So the association had taken out a loan in order to buy some of this land, and that loan had been taken out from actually like a white American businessman who had moved to South Africa, a man called I.W. Schlesinger. He set up the first cinemas and movie houses in South Africa. And so the dynamics of power meant that Schlesinger could raise the interest rates on the loan that the association as a whole owed to him. And that would put the whole farming endeavor in jeopardy. And in turn, Seme, evidence points to Seme also exploiting some of the Black families who bought land in this area. So charging them much higher interest rates when they bought land from the company than what he was paying to Schlesinger, presumably to try and make up for the shortfall that the company as a whole was struggling with. And so there were a lot of complaints raised against Seme himself, and it didn't seem like there were many accountability mechanisms in place that could help hold Seme and the board of directors to account. So that was one of the problems. Additionally, in contemporary times today, the people in Dachau and Driefontein still have the same title deeds that their great grandparents bought as part of the Native Farmers Association syndicate. So they're still landowners. They managed to resist the forced removals of the apartheid period, but people are very poor and survive off of social grants. So it's clear that ownership of land alone did not result in economic wealth for the owners of land in Driefontein. And this is for a number of reasons, paramount amongst them being the history of subsidies and basically a kind of white affirmative action for white farmers from about the 1930s until the 1990s, where it became impossible for Black farmers like those at Dachau and Driefontein to compete against white commercial farmers. And since they couldn't make a living from farming, people took on many, many tenants. So here is a situation that's more familiar in an urban area where people subdivide their plots, take on many tenants in order to make ends meet. And so this also means that each person's plot of land becomes smaller and smaller. And there's the need for more land to basically spread out and expand onto. And then the last thing I wanted to say, which is I'm sure something that you guys all know very well, but that it's clear historically, just like in the present, that collective landholding operations, collective ownership of resource operations of any sort are difficult and time consuming. So for instance, in the early 90s, when communal property associations were being developed as an idea, organizations in South Africa ran very extensive workshops, kind of land rights inquiry workshops, where they consulted and did interviews with people and basically had workshops where people drew up maps of where everyone lived and what their overlapping rights were in terms of passing through certain areas of land, in terms of access to water, in terms of access to amenities, in terms of shared areas. So in rural areas, things like shared grazing areas, for example. And it was these maps that formed the basis of some of the communal property associations that were perhaps more successful examples in South Africa in the 1990s and early 2000s. So in general, one of the problems of the land reform program in South Africa has been that government officials do not have the time, budget, or capacity to devote that amount of time and resources to running workshops of that sort on a community by community basis. But it seems like something that is very worthwhile doing, where those kinds of resources and skills are available to people to run those kinds of workshops. So these seem to be the spaces in which people felt that the kinds of land rights they had actually got recognized and often mapped out, and they were parts of that participatory process in marking out who had rights, land rights, where within the collective. So I think I'll stop there in terms of that little historical window.
Thank you. Thank you so much, Tara. Do you have any questions or comments? Greg, I'm noting you.
Yeah, that was so interesting. I had a question about the Native Farmers Association.
Yeah.
And so did the association lease land to the individual farmers, or did the farmers purchase land from the association?
So initially, what happened was that the farmers were all just listed as shareholders, and the title deeds remained in the land of the Native Farmers Association, remained in the name of the Native Farmers Association. But after several disputes, corruption disputes with the board of directors, including Seme and Schlesinger in the 1920s, then people demanded the right to be able to buy land from the Native Farmers Association. So they then bought land, but it seems from the deeds registry, which I visited until today, that in many instances, the name on the title deed didn't change from the Native Farmers Association to the family members' names, that there was simply a little annotation added to the deed for that particular plot saying there is a deed of sale between the Native Farmers Association and the families. So that's usually what people show as their proof of ownership.
Okay.
And the Native Farmers Association doesn't exist anymore, but there's like a
Mm,
shared understanding that they have been given rights by that association historically.
okay. Is that all, Greg?
That's it?
Okay. Crystal, then Maria.
Thanks. Thanks, Tara. That was really interesting. I'm not sure if I missed it, but I just wanted to understand the land that was the land in question, was it service land? And how did they afford infrastructure? Uh, was that something that the association paid for, or yeah, because one of
Mm-hmm.
and the reason I'm asking is, of course, the land that we are referring to in Philippi is not
Mm,
serviced,
mm,
and so all of those costs will have to be borne by probably the community or the city, hopefully. But wanting to understand, how does that work in terms of getting that kind of cooperation from government into installation of bulk infrastructure?
yeah, a very good question. So obviously these are hopefully also different times. Hopefully now, I know it's not always the case for the city of Cape Town and the Western Cape province, but I would hope that we would have a slightly more responsive government than the white minority government of like the 1920s who was servicing Dachakral and Driefontein. But Dachakral and Driefontein were basically sort of punished by the union government of the time, who said, okay, you guys have bought this land, you're on your own now. This is now privately owned land. We won't supply you with, there'll be no support, there'll be no infrastructure. And so people had to do that all themselves. They had to pool their savings and put that money into creating irrigation schemes, building houses, building schools, building clinics. There's evidence that that became harder and harder during the apartheid era, also as people's incomes declined and they were struggling with the lack of income from farming. And so they then wrote petitions to the kind of local magistrate's office and to what was at the time called the Department of Native Affairs to ask for some assistance in building things like boreholes and schools and fencing. And the government's reply to that was generally like, you bought this land yourselves. So if you want that support, you need to move out of that area into a homeland. In other words, a Bantustan became the Bantustans. So that's the kind of debate that was playing out in this place. But it seems that they were still making an argument then that people, that white farmers also own private land, yet they are being supported with infrastructural projects, yet black farmers are not. So, so there was a clear difference in the way that private landowners were being treated during that period. So I think, yeah, making those demands of a municipality and provincial government would make sense in assistance with infrastructural projects.
Okay, thanks, Tara. Do you have a follow-up, Crystal, or should we hand over to Maria?
I do have a follow, but I'm going to keep it for now,
Okay,
so that we can move the
okay.
process.
Maria?
Well, thank you. Yes, I just have a comment and a question. There's an article from Lessons from Dreyfus from Professor Lucy White, very interesting case. So I teach that to my students at the University of Puerto Rico here. And the question
Awesome.
is about the land. Even though the people can, the organization sell the land individually, and the effect in the registrar is that they put a note on that. The land remains collectively owned. Is there a segregation or not?
Do you mean, is there like subdivision of the land? Yeah, so initially there wasn't clear subdivision. Initially, it was more of a kind of social understanding of who owned land where amongst the 250 families. But then after these big corruption disputes of the 1920s with the board of directors, there was a clear subdivision of each of those small portions. So I think in the deeds registry, it'll have the list of like the plot numbers. So it'll be like plot 1 to, to plot 600 and something. And each one will be linked to a different family or different landowner who had bought that plot from the Native Farmers Association company.
Okay, thank you.
Yeah. And great to hear that you are using that article. I've actually briefly once visited the University of Puerto Rico back in 2017 with a couple of friends who I studied with at Michigan from there. So it's a pity I didn't know you then, but for next time.
All right. Yeah, do we have any more questions?
So, Atuna,
Yes, Crystal.
I'd like to retain my right to ask another
to
question
ask the follow-up. Okay.
Later, please. Thanks.
Yes. Yeah, so I was also just thinking that we should maybe give Tanvir a chance to lead her conversation and perhaps find if there are any linkages to Tara's input.
Thank you.
Yeah, Tanvir?
Yes, I'm sorry. As the quintessential young academic, I do have slides. I'm sorry. I apologize in advance. So I will share my screen.
Okay.
Yeah, hopefully you guys are used to just me having slides by now. Okay, cool. So, and the usual, can you see my screen?
Yeah. Yes.
Okay, great. Thank you so much. So you all told me that I was presenting on communal property trusts today. It's great because Tara already covered communal property associations, the history. I do want to say that they are different things from a legal perspective. So let's just start there. They're not the same thing, but I am very happy that in the presentation, I cover both just to kind of set out why they are different things and what exactly are we going to be looking at, right? So I'm going to start off with communal property trusts first, and what exactly do they mean? So a communal property trust, it's obviously a form of legal trust, and it's managed under a specific act, which is the Trust Property Control Act from 1988, right? Which allows you to hold, manage, and administer land, which tends to be, not always, tends to be typically restituted and redistributed land. And I highlight that because that's one of the main differences that you will see between a CPT, the Communal Property Trust, and a communal property association, right? a CPA, and it's on behalf of a defined group and beneficiaries, and it's usually rural or like land receiving community. It's usually rural. Tara has described even for CPAs tends to be in rural areas, but I think CPTs are more attractive when we're looking at things like Philippi, and I'll explain that a little bit later. So it's usually set up as an alternative to a CPA, especially when you believe as a legal advisor that, you know, the trust structure offers a little bit more flexibility and a little bit less of administrative burden, also a different kind of fiduciary control. You know, if you think I'm going a little bit too quickly, you can also slow me down, but it's just for the sake of, you know, not taking too long. So what exactly is a communal property trust? Let's look at certain key factors. We start with a legal personality. So it's not a different juristic person, right? Tara was mentioning, you know, one of the example with the CPA during history, having a different person being like a company, for example, is not a racialized person, right? With the communal property trust, you don't have a separate juristic person. Rather, you have the trustees acting in fiduciary capacity, right? On behalf of the beneficiaries at hand, right? You have a couple of trustees who are elected to act on behalf of Philippi, for example, if it was to be a communal property trust. So you'll have a board of trustees who are appointed to manage the land and any other income or assets that are derived from it. You have certain fiduciary duties and you're accountable to the beneficiaries under the specific act, which is the Trust Property Control Act that I've mentioned before. Importantly, the trust deed has to clearly outline who the beneficiaries are, which is usually the members of the land holding community. This is important to note because we're obviously trying to come up with a type of like, what kind of communal association are we looking at for Philippi, for example? So if we're looking at a kind of community where people are coming and leaving, right, and we don't really have control on who exactly is where, we need to make sure that people understand that the trust deed has to exactly outline who the beneficiaries are. So we need to know if it's person X, etc., etc. In terms of ownership and the rights that people have, it's important to understand that the beneficiaries themselves won't have direct ownership, right? Like they won't have property ownership of the land, but they will have beneficial interests in the trust's assets, right? So the trust will have assets and you will have an interest in the asset instead. You as a beneficiary will not have a right to the land, but you're going to have an interest in the land. You will be allowed to occupy the land. And that's like most importantly, the difference between the right to own the land that you will have as a private landowner, if you had owned that specific X space of land, as opposed to if you were a communal property trust. And I think we do understand that from the perspective of generally with communal land ownership, that's usually how it works, right? It's not private property ownership where you go and buy this piece of land and you own it. It tends to be rather there's a property interest in the land instead. So the foundational document of the trust must be registered with the master of the High Court. And the difference between the communal property trust, we're going to see that later, is there's less state involvement as opposed to the communal property association, right? Instead, the trust deed, that is that thing that is registered with the master of the High Court, that's what governs the objectives, the powers of the trustees, the conflict resolution. So if there are issues between the beneficiaries and the board, it's the trust deed that governs that, and the process for amending the deed. If you have an issue with the deed, how do we change the deed? That's also governed within the deed itself. And the trust may lease the land to people outside of the beneficiaries as well, right? So if it wanted to lease the land to people who are not from Philippi, it could do that. You could also farm it directly or partner with agribusinessmen as well, right? It would obviously all depend on what the document, the trust deed said, right? But importantly, the income is meant to benefit the community and the decisions must always align with the trust purpose. So also, by the way, please feel free to ask me questions as we go. But I wanted to say that I can't really see you guys right now as we have the presentation. So that's also fine. I have been given 3 examples of communal property trusts, except one of them was a communal property association, but we're going to talk about that as well. And I'm going to focus on them now, but I wanted to say, unfortunately, the problem with communal property trusts is there's not a lot of information available on them publicly. Right. So that's another issue, obviously, because the trust deed is recorded with a high court. And a lot of times it's not like with a communal property association where the state is very involved and there's a lot of public information. So there's the very famous Richterveld Communal Property Trust, right? The Richterveld community is popular mostly because of the case that reached all the way to the Concord. It's a community in the Northern Cape. This one wasn't an example that I was given by Akona, but it's the most famous example. So I would feel like I had failed you if I hadn't told you about it. So the case had reached the Constitutional Court, and it was mostly about recognizing the community's customary law ownership rights, right? Including the rights to the minerals, which was beneath the land. So it's not a lecture on community rights. I'm not going to go a lot into it, but the property trust was established specifically to hold and manage the restituted land. So importantly, this property trust was specifically incorporated after the land was restituted, right? So that's an important thing to remember. And it was in order to manage the benefits on behalf of the community. However, they quickly started to have issues quickly afterwards. And the issues was mainly those of governance, where apparently the trust had some internal disputes over management and decision-making processes. And there were efforts to leverage the land for economic benefit for the people who were living on it as well. But apparently, so these efforts included mining ventures, but there were faced with obstacles due to limited capacity as well as external pressures regarding mining the mineral rights. So that's kind of how Richterveld kind of fell through. One of the examples Akona gave me was the Ndabeni Communal Property Trust, right? So the Ndabeni community originally settled in Cape Town, but was forcibly removed during apartheid, right? And in 2001, a land claim was settled, and the Ndabeni communal property trust was established to manage 54.8 hectares of restituted land in Maitland. However, things got extremely hectic because the land was unlawfully occupied by unlawful occupiers, right? So this is where things get a little bit hectic, especially if you want to use this example for Philippi, because there's also unlawful occupation on Philippi, right? So you have an issue of legitimate, I want to say quote unquote, legitimate restitution that has taken place and a claim that has been accepted. But even though on the face of it, there is a title deed and restitution has taken place, the land claim has been settled, you also have unlawful occupation. So the problem is, and if anyone wants the slides, I can of course send it to you. The link in green is actually the link to a very good ground-up article, which shows that there is this tension where the unlawful occupiers are asking City of Cape Town to have access to service delivery, because under the current law, as most of you know, they are actually entitled to service delivery, and they've been there for a very long time, right? So the unlawful occupiers have been there for a long time. They are asking for service delivery, and they are blaming the Ndabeni Communal Property Trust for hindering their access to service delivery, including to water and sanitary services, right? Like literally basic access to services. And they're saying that there's more than 200 people living there and they haven't had access to a single tap or toilet. So the main issues here is obviously because of the unlawful occupiers, the Ndabeni community do not have access to their land either. And they also then have governance disputes. The trust has faced internal conflicts over trustee appointments and allocations of mismanagement of money. So this one's the most interesting to you, I believe, the Klipfontein community trust. This one was the hardest to find information on. Oh, I had to dig insane places to find this. So Klipfontein Community Trust, also known as the Philippi Community Trust, and it is based in Philippi. And the land initially belonged to a Methodist mission, from what I found. And the trust was actually founded in 1998, right? And in this Methodist mission, in essence, had an explosion of informal dwellings, so right, so unlawful occupation, and it began from 125 dwellings to 1,268, right? And this land occupation, then, the people kind of said, okay, this is getting a little bit out of hand. What we should do, right, to retain some of the value for the church, we should actually transfer the land to this newly formed body that we're going to call Klipfontein Communal Property Trust. So it was a legitimate communal property trust, and it's going to represent 776 members. The purpose of the trust was to formalize the existing settlement, right, to develop this residential township that is on Philippi. So there were literally like written out plans, and the first phase of the plan was to have 518 dwellings, which was going to be funded through institutional housing subsidies, right? But the whole idea was that there was an industrial zone along Lansdowne Road, and that was going to support the local economic activity. But then there was a major obstacle, which was environmental restrictions that you are probably aware of, which is that the Cape Town International Airport is right there. There's the noise zone, meaning that there's no residential development can be legally approved under national environmental legislation, which meant that the original township plan, right, according to the trust, would be unfeasible based on that. So that obviously came to a halt. But remember, the trust has already now been registered and everything's still in place, but the plan's no longer happening. So the provincial government steps into help and tries to say, okay, here's our proposed solution. We can secure alternative land for you in Kales River. Now, obviously, Kales River a little bit far. And the whole idea was because of the Methodist Church had an attachment to the specific land in Philippi, they wanted this specific piece of land, and that's where obviously the homes were. So the proposed solution had been, look, we sell the original Klipfontein land, right, in Philippi to help fund the relocation and new housing in Kales River that the provincial government had offered. However, not all community members had agreed to the location. A portion wanted to stay, but a portion wanted to leave, and there was already internal division. And as of 2006, back then, only 15% of the original Klipfontein land could be legally used for housing. And from the research, it looked like the CORC, a community organization resource center, began mediating between the rival factions within the steering committee. And I'm very aware now that there are many of you who know way more about this probably than I do. This is just from the research that I've done online. So please correct me if I'm wrong here. But this is basically all I got from the Klipfontein Community Trust. I will tell you that it was very hard to find anything on the Philippi Community Trust. Like, this is the only thing that I could find, and it was in a very obscure place on the internet that I even found this. Couldn't find anything else. So this is the examples of the community trusts. Akona gave me 3. I told you one of them was a CPA, and I'll talk about that later. So let's look at some of the challenges of the community trusts. The issue is that there is weak beneficiary participation and accountability. What do we mean by that? Remember, I told you you have a board and then you have the rest of the people, right? So if you were talking about Philippi, say Philippi like appoints Greg or Von or Egbert or something, and you're all the board, and then there's the rest of the people. It looks like the beneficiaries themselves, the rest of the people, they don't really participate, and the board just has to do everything, which is also why the board then tends to have a lot of sway to mismanage funds, right? Because the the beneficiaries don't really participate. There's also a lack of democratic structures, right? Unlike CPAs, which we're going to talk about later, and Tara talked about it already, CPAs usually must follow statutory, like democratic processes, votes, and stuff like that. Trusts don't really have built-in requirements. And especially because the state is not involved, trusts can pretty much do a little bit more of whatever they want. There's also limited knowledge or access. So beneficiaries don't usually know their rights in terms of what exactly can be done. And you can imagine if we're having to have so many conversations amongst us, right, who are pretty, like, now you brought in academics, you're all very educated, and we're still having so much debate to know about what's going on. So now to go back and try to have these same conversations and then tell beneficiaries, okay, these are your rights, there's going to not be a lack of know-how of what exactly are beneficiaries allowed to do or challenge, right? So there tends to also be an elite capture, trustees acting in their own interest or siding with powerful local figures, and just overall politicking. And that kind of leading to opaque governance. So you get the gist of it. Trustees have a hold of and a very high degree of power, right? So leading to frequent breaches of fiduciary duty. Sorry, I've mentioned before, as trustees, you have a lot of power. You can also allow other people to lease the land. So that in and of itself is huge. So it tends to lead to a lot of unauthorized land leases, right? And misappropriation of income, failure to distribute benefits. Also, so obviously you register the document I mentioned, the trust document, with the Master of the High Court, right? But the Master of the High Court won't usually have the capacity to proactively monitor the trust, right? As opposed to under, so the regulatory body, sorry, just let me quickly get that. Yes, basically the Master of the High Court will not usually have the capacity to proactively monitor the community trusts and so on. And basically just the usual, but that we can change it to your own trust deed. But generally trust deeds can be generic, outdated, but that's just a general thing. You can always tailor your own trust deed for yourself. And I don't think this one necessarily applies, but the general gist of it is that trust structures can maybe be too rigid on the membership lists. But again, we can make that and adapt on your own needs depending on the community. So lastly, I think what's most important here is trusts are private law entities, right? So the state has a limited responsibility or oversight compared to CPAs. CPAs, the state has to be constantly involved because there is a lot of state monitoring and accountability. Sorry, Crystal, I do see that your hand is up. Go for it.
Thanks, Tara. I just wanted to go back to your fourth point. I just, because there was something on succession, I didn't quite catch it.
On my
third point. Where was it now? Yeah.
Yes.
Succession planning.
Yes. So it tends to be that, for example, because trusts usually involves like families and so on, the idea of trustees dying and who then takes over when a trustee dies. But again, that can very much, these are general critiques of trust. You can also appoint other trustees to take over with succession. So, because obviously this kind of trust that we're talking about, communal property ownership trust here in this case, if a trustee dies, I don't think this will be an issue in this case. You can very much appoint another trustee. It can be very much amended in the trust deed, right? So this is why I'm brushing over the very generic critiques that do not apply for something in our scenario. But the problem is usually the replacement can be slow or contentious. But because Philippi, for example, is so huge, I highly doubt that the kind of trust deed we're looking at is only going to appoint 3 to 4 trustees, right? We need to make sure we tighten the kind of deed that we're looking at. So we make sure that we kind of have foolproof issues when we're looking at succession planning for sure. But I don't think this would be one of the reasons, for example, to not have a trust or enough of a disadvantage, if that makes sense. I think more of the disadvantage would rather be a lack of accountability, like I said, oversight gaps and stuff like that. So one of the things, for example, with state withdrawal is there's less support with dispute resolution, right? And fewer interventions when trusts are mismanaged. I think that's one of the things that's most concerning. So, for example, again, like because it's a private law entity, the with the trust being mismanaged, and for example, if there is no money, and where does that leave Philippi, for instance? Where do you go from here? Where do you have money to go where do you have sorry, English is failing me so hard right now. It's so late in the day. You go to court with what money, for instance, if you want to go and challenge something, is what I'm trying to say. As opposed if you were with a CPA, for instance, and you'd have a state intervention. Here, you're clearly a private law entity. You do not have the state intervening anymore. All the money that you had left and all the land, it's all gone with your private law entity. And you no longer even have an avenue to now go to court because you literally have no money. It's all gone. That's what I was trying to say. So this here, you'll just have the state to hand over the land and just walk away. They've washed their hands and they're done with you, right? So, and then this is another issue, but I don't think it's necessarily, it's a little bit of a different one, but usually the normal gist of with trust, there tends to be an incompatibility with customary systems, kind of what Tara mentioned with like communal land ownership and trust. So there's not really accountability. I didn't really want to touch on that too much because we are looking at urban land in the context of Philippi, right? Like you do have an informal settlement and people are used to having the usual Western way of owning land and leasing land in Philippi, right? So I don't want to touch on that too much. But the one thing I do want to say is trusts do often lack capital, business plan, and partnerships to make land productive. And without the state being involved, there can be poor planning, idle land, and mismanaged ventures if private investors are involved. So I know that it is something that Greg, Crystal, and Akona have mentioned before as well, like which is we do need the state for money. So if you don't involve the state at any stage at all, and you just have this trust aspect, then it's just only private. Where does the capital come in at all? Probably not anywhere. So it's something to take in mind. So that is the communal property trust aspect of it. I'm not going to go in detail over CPAs. I'm just brushing over it so that we know what the difference is because Tara mentioned it already. And just because I want to highlight that it is different to the CPTs and what about it is different. So we kind of touched on it in the first session that I was in for the first time, but the CPA is established under the Communal Property Association Act. Importantly, and I think that's the major hurdle we face, it's that you have to be a beneficiary of land reform, restitution, redistribution. You'll remember I had mentioned last time that that's the major hurdle we face with Philippi, right? Is that you aren't getting land as a result of land reform, right? That's the problem. And this is the one example that Akona had given, which is a property association, which is Mamre, right? And it's a rural community. It's in the Western Cape, and that was success. It was following a successful land restitution, and the title deeds in 2013 for 4,200 hectares were handed over after dispossession in 1986. And long story short, it was a pretty successful project. And there were some challenges, though. There were internal divisions and disputes regarding land use and development strategies, but there was also work with mediators and organizations to address these kind of challenges, etc. And there were obviously challenges with CPAs, which Tara has mentioned already, so I'm not going to go over them, but I just wanted to kind of have a why use a CPT instead of a CPA. And the reason I'm doing this is because it does sound like CPAs might not work if we don't have a land reform angle, right? So usually trusts are kind of simpler and more easier to establish than a CPA because of the CPA Act, but also because of the whole, especially for us, if you're not going to get a land reform angle, CPAs might just not be applicable, right? Also, trusts fall under the private law, etc., and it's easier to regulate than a state monitored CPA regime, right? So less state involvement can also sometimes be better depending on what your angle is. And you do sometimes have a higher standard of fiduciary accountability under trust law. So I do have to say there's a caveat here, and it's a very lawyer caveat. I think Greg will forgive me for that as a lawyer, which is that if you do have the money for it and you can go to court, then you have a higher standard under which you can hold them accountable, right? But if you don't have money, then you're screwed. So there's that. And sorry, and then finally, the trust deed can be drafted to fit the specific needs of the community and the land holding group, right? So the trust deed is very flexible. It can suit you very much in the way that you need it to be. Yeah, so look, the CPT is not part of a statutory land reform framework, as I mentioned before. It is used differently, and the state prefers to use CPAs, but obviously it's still valid vehicle under the common law. It's still fully legal, and NGOs have used them before. Private companies obviously use them as well, and like we've seen, land restitution cases use them as well, like with Richterveld, right? Like it's been done before. It's not completely out of this world. So I'm just going to leave it here because I think I've taken enough of your time. Thank you.
Thanks, Tanvi. That was interesting. Do we have questions or inputs? Felipe, I see you.
Thanks, Tanvir. It was very interesting, the presentation. I was very curious about what you said about the governance part of CPTs and how it's a major challenge. And I was wondering if you think like this lack of democratic participation and governance is something structural to the CPTs, or is something that could be corrected through good bylaws and create systems that allow more democratic participations, such as to preview some like board seats for residents, or an election system that residents participate, or even some decisions that the trustees cannot take. It needs to be taken by an assembly, or this sort of mechanisms that would allow a more democratic participation in CPTs, if that's possible, and if you see examples of this.
Thanks so much. I think that's a great question because I think it also speaks to how flexible the deed is, right? Like the trust document is. I think a lot of it can be incorporated in the trust document. I think it's just that people so far have used it in a super generic way, and they just take advantage of the fact that, why would you as a board member want to include the beneficiary? You can just abuse the power. So I think if you can totally want to include the beneficiaries, you should make it more democratic. You can use the fact that it's extremely flexible to include, like you said, instances where maybe the board shouldn't vote on this and rather have a democratic process of the beneficiaries should be involved in so many different ways. I think it's something that Egbert had mentioned before in terms of Philippi, is that they have very strong leaders and strong beneficiary involvement under certain things. So it would be interesting to see how they could bring that in and weave it in for the document. But yeah, that's very interesting. I did want to know Tara's opinion on this, is that I wonder whether they have the same issue with CPAs, with the lack of beneficiary involvement as well, because for some reason, I don't think it's something just CPTs have, right?
Yeah, thanks. Maybe Tara can just also say a little bit more about input on the chat section as well.
I should speak to what I posted in the chat.
Yeah. Yeah.
Sure. From what I know of CPAs, that is also a problem. So, like I said, like CPAs calling meetings, but not calling it at a time when most people can attend. So just basic things like that, where committees maybe starting off with a commitment to a very participatory form of democracy, but then losing that a little bit over time. The other problem with CPAs um, is that the government department on CPAs, I think there are literally maybe 3 people who work in that office to manage a few thousand CPAs. So the previous registrar of CPAs, Site Gombi, would be actually fantastic to talk to as well, because he knows the ins and outs of all CPAs, and he would be able to tell you which CPAs were in urban areas and how they worked and stuff. But that was his main point, that they couldn't actually follow up and intervene on issues of accountability within CPAs because they just lacked the resources to be able to do so. So that's also something to bear in mind, that CPAs will be overbearing in the sense of the government will ask for an annual report every year for stuff like that, but they won't necessarily assist in the way that you maybe want them to assist. Um, and then, yeah, so I know of a CPA, for example. Oh, my watch is talking to me. I know of a CPA, for example, in the Eastern Cape, called Masakane, near the town of Alice, where Fort Hare University is located. In that instance, they were farm workers who were occupying the land and then wanted to create a CPA to take ownership of it. So it wasn't a land restitution case, and they established a CPA along those lines. So there are some instances where, like, occupiers have been able to establish CPAs, but I agree with Tanvir that in most officials think of CPAs in the context of land reform, and might be a bit like, whoa, why do you want to establish that here? That's not for you guys. That's for land restitution. So you could encounter that problem.
Right. Thanks, Tara. Do we have any more questions? Yes, Maria.
Thank you. I just want to clarify, Tanvir, did you address who appoints the trustees?
If I'm not mistaken, it is the beneficiaries who appoint the trustees. Yeah, there is a process through which, Tara, like, correct me if I'm wrong here, but there is a process. Yeah, no? I'm not clear on that, to be honest. Okay, yeah. But yeah, basically,
Yes, I think so.
it is the beneficiaries who appoint the trustees. I'd have to go take a look at the act, but that's usually how it goes, if I'm not mistaken.
Okay, thank you. And the second question was, if the trust doesn't have any juridical personality, under whose name is the land?
Okay, let me quickly do the right lawyer thing and go look it up before I give you misinformation. I know it doesn't have a separate juristic personality, but let me go see then under whose name I'm not a very good private lawyer, so let me go look it up and then get back to you.
Okay. Yeah. Vaughn, whilst Tanvir is looking at the stuff up.
Yeah, firstly, just to Tara and Tanvir, thank you so much for all this wonderful information. It's so helpful for us to get our heads around just the bigger picture. Then just also to state that on Felipe's question around the involvement of beneficiaries, I know that the CPT can have clauses put into it that ensure beneficiary involvement and participation in important decisions, assemblies, etc. I think there's also something around the nature of the community that's actually using the trust that also makes a big difference. For example, the Cliffontein communal land trust that you mentioned, Tanvir, which is what Candice is actually working on it, currently. It was actually first purchased by 5 slaves, actually 5 freed slaves, back in the late 1800s. and the Methodist missionary that assisted them to make the purchase kept the title deeds in the Methodist Church, and eventually the Methodist Church became the owner of that land in the eyes of the community. And the court actually instructed the Methodist Church in 1997, after that court case, to return the land to the beneficiaries. And they were given 30 years to do that. And that's why the Communal Land Trust was established. But what's interesting about that particular community is because of this history and the relationship between those beneficiaries as descendants of those 5 freed slaves, that community is a very very cohesive, very strong social group that see themselves as the owners of that land through their forefathers, although they were denied the right to purchase the land legally at that time. And so this community is a very close-knit community. It's a very a community that really sees themselves as a single group, separate from the other communities around them. I think it's somewhat different when we look at communities like Winnie-Madikizela and Seskona, where people have been there for the last 10 or so years, and they've moved in together, but they don't have that same history of having sort of being these family units that have grown together over the many, many years. And so I think that therein is also a challenge when it comes to getting beneficiary involvement. There's a closer sense of beneficiaries have control over who the elected trustees are in the Klipfontein community, and there's a lot more, I think, political maneuvering happening in these younger communities where there's less cohesion and less sort of close-knit relationships, and unless people are coming from the same village and moving into an area together, which does also happen, you tend to have a lot more political maneuvering happening, and that also makes for a weaker beneficiary involvement, or at least in some ways greater opportunity for these power players to move and make decisions without the whole community being considered. Just a thought around it.
Thank you so much, Von, for that input. I don't know, Candice, do you perhaps want to come in at this point around your experience having worked with the Klipfontein, and also just speak to your comment on the chat section?
Oh, okay. Hi everyone. So I'm a practicing lawyer and I work with communities. I'm also a pro bono lawyer, so I don't charge for my services. I spent a lot of time working on land claims, so I'm familiar with CPAs and CPTs. So the question I answered is, in whose name is the land registered? It is registered in the name of the trust. So that's the answer. In all matters where land is involved, the land is registered in the name of the trust. In regard to how to make the processes more democratic, South Africa has standards of accountability set out in our corporate governance principles. So these are dictated by all our instruments. So from the Companies Act to the Trust Property Control Act to Non-Profits Act, there's a uniform standard of accountability and democratic principles. I think the failure in our system as a practicing attorney is where the community is not sufficiently trained and given the authority to act, and the process is created like the speakers both said. He said you would need to create the democratic processes within the governance documents, within the covenants themselves. So, for example, a trust deed would have to say that specifically the beneficiaries would have a nomination and election process of trustees that they would appoint, so that the power of appointment of trustees would then sit with the beneficiaries. And depending who the founder is, sometimes the founder of a trustee might be land claims. If it's coming to the land claims process, It might be a CPA coming out of a CPA process that wants to transfer the land into a trust. It might be the owner of the land who's setting up the trust in where there's private land ownership being given over to a particular community. So it's obviously the people who are drafting the documentation has to have extensive consultation and engagement. I've often found that when there's a corporate entity on the other side, like a mine or a private company, and they would just prepare governance documents under very strict controls. They envisage a small board on corporate lines. They envisage a small board that makes all the decisions, and then you have years down the line the levels of corruption and lack of accountability that comes in. Often when you have government involved, they become quite laborious in the governance that they put in, and so it becomes quite complicated, and so people don't understand all the things that they have to do and the time periods that they have to do it, and then they don't meet the deadlines, and then they fail in one, so they fail in all, like a domino effect. And then what I've found in the years that I've been doing this sort of work is you really need the intervention of people who understand community development, who understand the history, as put out by Tara, the history of people to the land, and then approach it with that kind of empathy and compassion that says, how would you like to elect your beneficiaries? How would you like to elect your leaders? What are your concerns? What do you want to prevent from happening in this particular trust? And I'll give you a good example. I did assisted the 13 communities that claimed the Kruger National Park between Skukuza and Palabora. And there's 3 levels of conflict that we have in current South African society. So I'm not dealing with the past, I'm dealing with today. The 3 levels of conflict, excluding government, because I think government is the 4th level of conflict that comes in. The 3 levels of conflict is you have the people who want change, the community leaders who want progress, who want to build, who want to see industrialization, who want to see economic growth, and they are the ones that drive the process. And they often come from their parents, the grannies, the Fundisi, all of them that come in, the priests who have run the land claims process, but they offer like an old age, middle age kind of status. You would then have the traditional or the royal houses who believe that land vests in them and they must decide who must get the land and what must be done with the land. And the holding of the land without development of the land is a wealth in itself. And so they don't see the development that possibly your teachers and your priests and your, municipal workers and the nurses, that level of middle age, sort of elderly people are saying we must progress. And then you have the young people who have no attachment, political or otherwise, to the land, and it's a commodity like any other commodity. If we had a land, we can start a business. If we had a land, we can sell it. If we had a land, we'll build rooms and we'll rent it out. It's just about the economic opportunity they can get, but the land itself is not important as the land. It is only important as the means of an income. So if they lost the land, they'd find another form of income. And then, of course, the 4th entity, which is government, because there's so much corruption. So depending on where your land is and how valuable it is, you will get a great amount of government intervention, and it may not be direct government intervention, like appointing trustees, or you would get subtle government intervention in the form of ward councillors coming in and disrupting community meetings and those sort of things. So while we love community engagement and we want a wide collaborative processes, and it's built into our governance principles, you have to have an annual general meeting every year that involves the community. You can create within your trust opportunities for community to elect trustees. You can set aside certain items on the agenda that there are community decisions, and certain items that are like management and only for the trustees. So the trustees don't have those massive discretion, like when you're disposing or alienating land. that because it falls in the realm of private law, it is wonderful and it is flexible and you can detail and make it your own. But before you get there, you've got to take an entire uneducated population, and I'm not saying they're illiterate or they're not a legally educated population. You bring them up to speed, explain to them what their rights are first, and tell them how they can, give fulfillment to their rights before you then allow them to engage in this sort of like politically in their own trust. I'll stop there.
Okay, thanks, Candice, for that input. It's really useful. Tarsila, and I'm also looking at time, Greg. Please do not kill me.
Well, I just want to actually reinforce what Candace just said. It looks like to me at this point that the main challenge is not institutional, is not legal. It looks like that we have many possibilities actually, but maybe the greatest challenge is related to mobilization and how to guarantee that community will be part of this trust. And of course, I think Maria from Puerto Rico experience and me in Brazil, we can definitely share some possibilities because of course this is a common challenge and somehow we are trying to address it for, well, many years by now. But it looks very, very interesting, the possibility to work to transform this institutional and code framework into something more democratic and something that could definitely empower the community and not just serve as a formalization tool or something like this. So, well, thank you very much, Tanvir and Tara. It was really great to understand in so deep a way all the possibilities with the CPTs and CPAs. And I think we have now a more clear path to take related to this community aspect, how to empower the community in this framework. So it's just to point that out.
Good God. Oh, I'm muted. No, thanks, Tarsila, for your input as well. So I think the conversations, I'm imagining that they will continue in the working groups, Greg, specifically around the work stream on acquisition. I think that is where this conversation will most likely unfold, and that is where we'll get to distill all of these thoughts and inputs, and that will help us in choosing the right instrument that can be used for the community in question. Which takes me to our next item on the agenda. We're left with only 3 minutes on this call, and I'm imagining that one, I would have loved to get a mandate that everyone that is on the call now will be participating in the working groups. I think that's the first thing, and I don't know, Greg, if we need to sit as the planning group and then allocate people to the different work thematic areas or not. I don't know. Crystal, any thoughts on this one?
Yeah, I think thank you. I mean, I can't say thanks enough, Tara and Candice. Those were really thank you for really preparing so well in capacitating or strengthening our capacity in understanding all of this, because when we started, we said this was new for us. So thank you again for that. Greg, I'm thinking that maybe, yeah, we don't have much time, but there are people that might not know what Akona is talking about the working groups. And so maybe if we could just if you could perhaps just give us a quick overview, oversight around this new phase that we're going into, or that we're hoping to go into, and then to encourage everybody to sign up. And Akona, I think I wouldn't like to allocate people to working groups. I think it would work better if people chose as to where the interests are. I think that, yeah, you can't put me into property taxation. You would get nothing out of me. That's not my area of neither interest nor expertise. So I think it's important that people would go into a working group that like to delve into deeper. Craig, would that be okay with you? Quickly an
Yeah,
overview of the.
yeah. So those presentations were fantastic. Thank you so much. The idea overall is that we would have a series of kind of larger group, kind of mutual education conversations. And then after that, we would kind of do a deeper dive into specific topics and establish one or more working groups to work on those. So far, we've identified 5 potential topics, which I think we'll definitely want to kind of revisit based on the presentations from today. I can just give you real quickly, just to share what we're thinking about. So the topic of, who will be the ownership entity, which was the focus of the conversation that we've had today. How will the residents relate to this ownership entity? And then a third related one is, how will the land be acquired? Additional topics for discussion could be upgrading of infrastructure, which kind of is one of the primary purposes of this effort. And then the issue of property taxation. Once the ownership changes, will there be property tax obligations? Who will pay that? How would the taxes be collected from the residents, etc.? So what I'm thinking in terms of a next step is I'll follow up with a very short survey, which will identify each of these topics. I'll ask each of you to identify which topics you're interested in being, you're particularly interested in, and then we can use that to kind of pull together working groups going forward. The other thing is that what we've talked about is recruiting additional folks to participate. That could be community residents. That could also be city staff who we think might be sympathetic to this effort. And we have a kind of our next planning meeting with Akona, Crystal, Maria, and Tarsil will be the first week of June. So I think I'll send out a survey before that, and then we'll meet that first week of June to kind of put together the working groups and follow up with you afterwards. Does that all sound okay?
Yep. Works for me.
All right, good.
Yeah.
Okay.
Yeah, just to say that we are hoping that the working groups would be working in parallel, and so and then we would come together as a collective from time to time to share the learnings and what we've been able to ascertain, and hopefully we would then be able to develop some kind of pilot plan out of that. Yeah. And I also just want to check, maybe, I don't know, and I'm pushing it here, but show of hands, would everybody be keen to be part of the next phase of this process?
Yeah.
Guys, I do lots of facilitation. I make people put up their hands and sign in the air. I won't make you do that.
Yeah.
Okay, thanks very much.
Okay. I guess that's it then. We'll have the planning meeting. Greg is sending out the poll for the working groups, and that will be before our planning meeting, which takes place on the 4th of June. And then we'll communicate with everyone in terms of the different working groups and possibly have the dates for the bigger group discussion or the platform again. Thank you for your time, and thank you again, Tara and Tanvir and Candice for your valuable inputs. Thank you so much.
And the presentation will be shared with everybody.
Yes, the
Thank you
presentation
very
will be, yeah, I'll share the presentation with everyone. Thanks, everyone.
Yes,
Bye.
thank you.
Thanks for having me. Nice to meet you all.
Okay
Bye.
then. Bye.
Bye-bye.
Bye.